The truth is the only thing that matters, but often the road to get there is mined with lies, deaths, deceptions, and cover-ups. Sir Isaac Newton, besides being recognized as one of the greatest mathematicians and physicists of all time, was also the warden and master of the Royal Mint and prosecuted one of Britain's most serial counterfeit coiners and confidence tricksters, William Chaloner. Chaloner was hanged by the neck on the morning of March 22nd, 1699, and then publicly disemboweled, a gory end for a man responsible for so much suffering and death himself. Throughout history, greed has always been the hobgoblin of capitalism, the mischief it makes a canker on the faith of capitalists. We sometimes forget that the pursuit of commercial self-interest was largely reviled until just a few centuries ago. Now even the devil takes Visa. Over time, the pursuit of naked self-interest became rationalized and the moral vision of society changed to become a war of all against all to get as much as possible for yourself and your offspring, and the devil take the hindmost. This coincided with financialization and globalization, where the gains made by financiers and corporations came at the expense of the wider society. Financial gain can be a slippery slope. All too often, success seems to lead to greed, and greed, of course, is the great corrupter. Now some notorious individuals in the world of finance found opportunity presenting itself and temptation too much to resist, like Bernard Madoff, Barry Minkow, Dennis Kozlowski, and Michael Milken. Obviously, when it comes to the stock market, the stakes are high. And for would-be swindlers, though the rewards may be great, so too are the risks for their victims, if not for themselves. Over the years, many Wall Street darlings have breached the trust, both of their companies and the general public, to satisfy their own insatiable hunger for money and power. Here's a few more: Bernard Evers, Andrew Fastow, Jeffrey Skilling, and Elizabeth Holmes. But fraud is not limited to American stock swindlers alone. No, foreign companies also trade on U.S. stock exchanges and sometimes swindle their U.S. investors. In fact, some of China's tech darlings began tapping U.S. investors in the early 2000s when mainland capital markets were unsophisticated and the strict profitability requirements of PRC exchanges shut out most fast-growing tech firms. To list in Shanghai, for example, a firm had to show 3 years of profitability. Nor was Hong Kong a viable option, as until recently it banned the use of dual-class structures favored by tech entrepreneurs. So off to New York went Baidu, JD.com, Alibaba, and dozens of other Chinese unicorns and near unicorns thirsty for growth capital. There they found Americans eager for exposure to China and its explosive growth. With few alternative China pure plays, investors jumped at the opportunity to invest in these Chinese tech firms' IPOs. While Washington and Beijing battle over trade, a worrisome cross-border financial link has largely escaped scrutiny. Americans now collectively own most of the public equity of China's biggest tech companies, including Alibaba, Baidu, and Weibo. This relationship is strange. Imagine if the Chinese own most of Amazon, Facebook, and Google. It's also extremely risky, at least for American investors. The relationship seemed like a win-win. U.S. investors got to own fast-growing companies, while China obtained funding for its young tech companies without destabilizing manias and panic. For perspective, U.S. investors have poured more than $100 billion into Chinese companies going public in the U.S., more than 70% of which are Cayman-based. But the symbiosis began to break down as these hyper-growth companies matured. American investors became dispensable and thus vulnerable to expropriation. Public investors in a firm with a controlling shareholder always face the risk of an unfair take-private scenario. But investors in U.S.-listed Chinese companies are particularly vulnerable. Most incorporate in the Cayman Islands. This jurisdiction affords investors much less protection than Delaware, home to most U.S. companies. The Cayman Islands evidently possess a well-developed body of corporate law, but the level of regulation is relatively light. And Cayman and U.S. judgments are not enforceable in the PRC. The location of these Chinese firms' assets, records, and insiders. Chinese controllers can thus squeeze out the minority on terms that would make American controllers blush. In a precedent-setting case, the Renren derivative litigation case that will have long-term positive impacts, our news team sits down with Bill Reid and Nate Palmer, partners at Reid Collins Tsai, who won a $300 million settlement against the Chinese company Renren Inc. The action alleges a complex scheme by Renren insiders to take the company's billion-dollar investment portfolio for themselves and created a new case law to strengthen investor protections from cross-border fraud and financial misconduct. It is the only recent derivative case brought under foreign law that has succeeded in holding international companies to account in U.S. courts. In this insider-exclusive Justice in America Network TV special, Justice in America, the Chinese-based Cayman Islands Renren fraud scam, our news team sits down with Bill Reid and Nate Palmer, partners at Reid Collins Tsai, to show how they won a $300 million record-breaking settlement from a China-based Cayman Island company, Renren, in a New York state court. Bill and Nate have earned reputations as unyielding trial lawyers who repeatedly represent clients against big companies and the Goliaths of the world, and repeatedly win. They have earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Texas and across the nation. They have built substantial reputations nationwide by consistently winning cases other law firms have turned down. And their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Austin, Texas. It is my great pleasure to introduce Bill Reid and Nate Palmer to the show. Welcome to the show, guys.
Good morning.
Morning.
Tell our audience a little bit about your firm, what type of cases you generally handle.
We call it complex financial litigation. It comes in all varieties and shapes and forms, but generally there's some financial transaction or financial event or contract that has winners and losers. And we like to represent the people who lost but who shouldn't have lost.
That's a great way of putting it. And you've run across a lot of companies like that because companies are run by human beings, right? And human beings have frailties. They're not perfect. And one of those themes, I would say, that runs through a lot of people who have access to a lot of money is the word greed, right?
Greed is the fuel of our business. If it wasn't for greed, we would not have a lot to do.
That is true. We're here today to talk about a company which is a Chinese tech company called Renren. In Mandarin, that means every man. They attempted to be the equivalent of Facebook in China, right? The Facebook of China. Came to the United States, were listed on one of the exchanges, one of the American exchanges, and raised $700 million, correct?
Yep.
Tell our audience what happened after that.
The Facebook of China turned out not to be that good of an idea, and it didn't pan out the way they had hoped. And so they took that money and began investing in a variety of companies, all within the tech space.
What's wrong with that?
Nothing with just investing the money. What was wrong with it was what they did after that.
And what happened?
Well, eventually, some of those investments turned out to be really profitable.
And one of them was in SoFi, correct?
One was SoFi, the big student loan finance company. And the insiders decided that those assets were valuable enough, they should take them for themselves.
Remember, the insiders included SoftBank, the big Japanese bank. Yeah. So there were 3 insiders who controlled this company, and the assets were actually worth, they had a spreadsheet that our team found showing that on the date of the going private transaction announcement that they prepared a spreadsheet demonstrating that the assets were worth $1.3 billion. They could have just paid the 20 or 30% minority shareholder base their fair share of that, but instead they chose to get a bogus valuation saying those assets were only worth $500 million, and for that they only had to pay 20 or 30% of a much lower number. So it's kind of the worst kind of greed. They already had a bunch of profit. They owned 70 or 80% of the company, and they could have just paid the minority its fair share. Instead, they chose to basically steal it.
Yeah, let's talk about some of the problems or the hurdles that you had in prosecuting this case.
There were many.
A lot of Chinese tech companies are incorporated in the Cayman Islands, just like a lot of U.S. companies are incorporated in Delaware.
Want to hear an interesting fact? The U.S. exchanges trade about $1.7 trillion in foreign-listed ADRs, American Depository Receipts. We estimate that approximately 40% of that number, or close to $700 billion of market cap in the United States, are Chinese. They're all incorporated in the Caribbean. So they're based in China, incorporated in the Caribbean, yet traded on our exchanges.
And why are they incorporated in the Cayman Islands? What advantages do they have?
They are very difficult to hail before a U.S. court when they're based in a foreign country, incorporated in another foreign country, and have little or no operations in the U.S. And unfortunately, our law says that simply listing on a U.S. exchange by itself is insufficient to give rise to jurisdiction. You need something more.
Right. Now, we spoke real briefly, Nate, about why don't they just raise money on their own exchanges? You know, why do they come to the United States? And I think you and I talked about the fact that the Chinese equivalent of the Securities Exchange Commission, for example, require them to be, what, profitable for 3 years?
I believe that's correct, yeah.
So we leave ourselves wide open. The stock exchanges are leaving itself wide open to be defrauded, aren't they?
I think they do, and it's even more interesting in that the U.S. doesn't require those companies to comply by the same reporting requirements that U.S. companies have. So they even have a lower bar in the U.S. when it comes to telling their investors.
You want to hear something even crazier? Section 14 of the SEC rules polices fraud in connection with any public security. So fraud in connection with financial statements, going private transactions supported by bogus valuations, those are all actionable under Section 14 of the securities laws for domestic companies. But under the Code of Federal Regulations, a, quote, foreign issuer, which all these Chinese companies are exempted from Section 14 liability, which means that they can, without any repercussions, lie to our U.S. markets without a securities fraud claim.
You know this. A lot of other people know this. Why isn't it changing?
I think Congress either doesn't understand or doesn't want to promote more securities litigation. But it's unbelievable. Exxon, IBM, Mobil, any U.S. company, Apple, they cannot lie to a U.S. exchange. Yes. They would be held liable under Section 14. But we allow these Chinese companies $800 billion of market capital to lie till the cows come home. It's unbelievable.
Do you think that the exchanges and or the SEC don't put these restrictions on these foreign-based companies because they want them to invest in the exchanges here in the United States?
Absolutely, it is in the exchange's interest to have lower regulation to attract more dollars. The question from a policy standpoint is, should the U.S. government want that sort of behavior? And I would suggest to you the answer is obvious. No.
So take us through the litigation history here. What happened?
So here's what happened initially. A friend of mine named Alex Shogi, who runs a hedge fund called Oasis Capital Management, told me these facts. And I was like, this is insane. How do we sue them? And so I turned to the surgeon over here, Mr. Palmer, and said, Nate, go figure this out. And the riddle that he was asked to figure out on an order of scale of 1 to 10 of complexity was about a 12.
So the big problem was getting jurisdiction over these companies.
How did you do that? I think you found an old case, couple hundred years old or something like that, right?
It was from the, I want to say
1989?
Yeah, 1970s, 1980s. It was an older case. But because we were looking at it, there's not a securities law angle to this, right? So we're trying to bring a company claim So it's a derivative case. And the big hurdle there is in the US, to bring a derivative case, you have to have personal jurisdiction over both the company and the individuals that you're trying to sue. And that presented a problem here. We had one guy, unknown where he was located. We knew he was a US citizen, but we couldn't track him.
This is Joseph
That
Chen.
was Joe Chen.
Right. A Chinese person that was born in the United States, correct?
He was a US citizen.
Who was the head of this company, Renren.
Then we had David Chow. We knew he was in California. And then we have Renren. We have to figure out where we can get all of them. And in this case, that was the puzzle piece, because the law in each state is different over how you have jurisdiction over these people. And the key was New York, because when I went through the securities filings, the deal docs, you had all these connections to New York. The money had to flow through New York because this was a New York American depository receipt.
Yeah. Did they lie to the court about they didn't have a bank account or something like that in New York? Didn't I read that?
Mr. Chen was forced to file, quote, corrective affidavits in the trial court and the appellate.
Yeah. In other words, he was forced to correct his previous lies.
About where he lived. He lived in Arizona.
He might have had an excuse on the bank account thing.
And by the way, you know, I mean, in a way, this is criminal. I mean, if somebody went into a bank with a gun and attempted to rob the bank and took the money out, and it's almost the same thing. Why wasn't he prosecuted criminally?
So, Steve, here's the answer to your question. We put young men in jail, mostly young men of little means, in jail for 10, 20 years for drug-related offenses, have done so for decades. And meanwhile, what are they doing? It's a crime of greed. They get $50,000 to drive a truck for one day, and they're tempted to do that. Wall Street criminals, which is what they are, steal millions of dollars and never go to jail. Because in this country, for some reason, we view white-collar crime as somehow acceptable. It's not. It's just a crime of greed like any other crime of greed. And so the only way to hold people like that accountable is to bring these sorts of claims. Yeah. But jurisdiction was only one problem. In order to bring a derivative claim, as Nate just said, you have to look to the law of the jurisdiction in which the entity is incorporated. So in this case, that was the Cayman Islands. So we had to figure out how to get jurisdiction in New York. Nate just explained that to you. That took them probably 2 months to figure out. Then we had to bring a derivative claim under the law of the Cayman Islands, not U.S. law, which required us at the time to go to various QCs, Queen's Counsel, but now that the Queen has passed away, they're now transformed into KCs, or King's Counsel, and those are the lawyers that go to court in the English system, and they had to guide us through, and that was an old case, Foss versus Harbottle, which was a young case for English law, 1843, but an old case for us.
Wow, so complicated. And then the final result is what?
We settled the case for what we believe to be the largest direct pay cash settlement in U.S. derivative litigation.
And the only one of its kind, too, right? Was there one other one, maybe?
Whenever you say it's the only one, you never know. I mean, what we are aware of is that we are aware of approximately 24 Cayman derivative claims sought to be pursued in the U.S., and we're aware of only one other that succeeded in any form.
And you settled the case for how much?
$300 million directly paid to the minority, which if you were to equate that to a company-level recovery, was equal to the $1 billion that was stolen. It was basically 100% recovery.
Yeah, talk to us a little bit about some of these Chinese tech companies being incorporated in the Cayman Islands and what their strategy is here in using American exchanges, for what purpose, and what do they do after that?
It seems that there's a strategy. I'm not sure, what's in their minds, but a lot of these companies come and list in the U.S. and they initially, the prices shoot up. They make a lot of money. But eventually that peters down. But the company has the cash, right? They've already collected all that from the IPO.
Or the assets purchased. And then they decide to go private, and because the price has fallen over time, they're able to buy the company back at a discount to what it was initially listed at, and they walk away with that delta in assets or cash. Okay, so when that happens, there is a right under foreign law in the Cayman Islands and Bermuda, and we have about 6 of these cases going on right now, to pursue what are called appraisal rights. So if the company goes private at $50, but it's really worth $100, you can go to the country of incorporation, be it Cayman or Bermuda, and ask for your $100 in the form of an appraisal action. We have a couple $2 billion of those claims right now associated with 6 companies that went private for, we say, far far less than what they're really worth. But interestingly, in Ren, there was no availability of this appraisal remedy because they cleverly didn't take the company private. They just took its assets. So there was no appraisal rights remedy. There was no remedy, period, other than this case that basically Nate mostly thought up.
Do you end up litigating these cases down on the Cayman Islands?
So the Cayman Islands is a difficult jurisdiction to litigate in, but appraisal rights is a statutory remedy, and we are pursuing those claims through Cayman Council in the Cayman Islands.
Now, when some of these companies take their companies private, that's not the end of the story. What do they do then?
They relist, usually in China, and then reap the benefit of the true value of the company. So you got to understand that when you are incentivized to take a company private, your public filings don't necessarily paint an accurate picture of the company leading up to that, with the purpose of intent of driving the stock price down so you can buy the company for even less.
Right. You know, when you handle cases, you said you have multiple cases like this going on right now. Do you ever coordinate with the SEC and say, hey, why aren't you guys looking at this a little bit closer?
We have spoken to the SEC, but they, at least during the Trump administration, had no interest in anything. I don't know whether that's changed, but I have seen no change on their part. It's something they ought to look at, both in terms of changing their own rules, but also in terms of looking at this for themselves.
Obviously, because of the success of Renren, you have other clients who have come to you for the very kind of same sort of legal process. How do you select the companies that you eventually represent?
So your question would imply that we only represent companies. We represent all sorts of people.
Individuals and companies.
Bankruptcy trustees and the like. So we go through a process because our only asset really is our time. So we go through a process that is designed to essentially ferret out the cases that we really and truly want to devote our time to. Because we only have 41 lawyers, so we can only do so many cases at a time.
I want to thank you both for being on the show. Congratulations.
Thank you, Steve.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.